Sir, you seem down since when we were in the office, until we get here. What's on your mind?
I've been thinking about my family and all the property and assets I have. There are so many things to consider.
That sounds overwhelming. What are you planning to do about it?
Honestly, I'm not sure. I've been contemplating how to make sure everything is handled properly, but it's a lot to think about.
Have you considered writing a will?
What do you mean? Wait, are you saying you want me to write a will because you're planning something? Are you wishing me death?
No, it's not about that at all. It's just a practical way to manage your assets and ensure everything is taken care of.
Oh, I see. I was worried there for a moment.
I learned that on Aribabla TV, that a will is just a legal document that helps you decide how your assets are distributed when you're gone. It's a good way to make sure everything is handled according to your wishes.
That makes sense. But how do I actually write one?
You can find all the info you need on Aribabla TV. They have great videos explaining everything about making a will in Nigeria.
Alright, I'll check it out. Thanks for clearing that up. I would be able to sleep happy and relieved tonight.
Welcome to Aribabla TV. We are here today again to take you through the law and the position of the law when it comes to will writing. God has blessed you with many properties. You are able to amass wealth, whether you have a landed property or you have movable or immovable property. But your mindset is telling you that, how am I going to leave all this property behind? Especially when you have families, you have wives, you have children, but you don't know the way to go about it. The most important thing you have to do before going is for you to have a will. Talk about writing a will. It's as if we are planning, or they have a mindset that, oh, this person is about to die. That's the reason why he has to write a will. Yes, death is inevitable, but at the same time, we never can tell when the death is going to take us. Just the way we have to plan ahead and write a will. Because when there is no will, such person is considered that he died intestate. And when someone died intestate, it may even cause a lot of difficulty or issues for those left behind compared to when there is a will. Now, what is a will? A will is a legal expression of the intention of a person that this is the way they should share his property. You have to make the intention clear by putting it into writing. What is the characteristic of a will? For there to be a valid will, such will must clearly show the intention of the testator. Another characteristic you have to see in a will is that the will is invariably revoked. You can consider that, oh, I've made a will, but it got to a level, you now decide that you want to revoke the will, or you want to rewrite the will, or you have some other property or some other things to include in such will. The law allows you to do that, and that's another characteristic of a will, that it is revocable. Now, having the mindset of making a will, what are the requirements of having a valid will, or for the court to consider that this will is valid? Number one, such will must be in writing. Secondly, the testator, that is the person who is writing the will, must sign that will in the presence of two witnesses. Thirdly, those two witnesses must sign their signature or append their signature in the presence of the testator. The first option given, or the first requirement, which is that the will must be in writing, does not necessarily mean that it must be in the handwriting of the testator. It can be done by another person on his behalf, but in his presence that he actually consented to the writing. The will may also be in printed form, but the actual fact is that such will must be in written form. For the second part, that the will must be signed by the testator. In this case, the testator must sign on the will at the foot or at the end of the will. Therefore, anything that is in the will but it is stated after the signature will be discountenanced by the court. The testator has to be careful of where he has to put his signature. The third requirement, that the signature must be done in the presence of two witnesses. It has to be noted that these two witnesses must be present at the same time. So if a witness is before the testator and the testator signs on the will, without the presence of the second witnesses, the will will be considered invalid. So they must be present at the same time. The fourth requirement, that those two witnesses must also sign their signature in the presence of the testator. So the law allows that it is not a must, they must be both present when they are appending their own signature. But at least each one of them must sign their signature to the will in the presence of a testator. These are the requirements of a valid will, and there are things you have to consider when writing a will. However, where there is no will, what is the way out? What is the position of the law? These are what we'll be looking at in the next episode. Thank you very much. Subscribe to Ariba Law TV.